have all been very speedy. So we have plenty of time to have all the questions during the panel. And now Gaetano Dimita, the Senior Lecturer International Intellectual Property Law at the Center for Commercial Law Studies at Queen Mary University of London. Gaetano focuses his research and teaching on games and interactive entertainment law. So let's hear what he has to say.
Thank you very much. Thank you very much for having me. Sorry, I was just noticing the photos. I was holding a glass of wine that has been removed from the picture. Before I begin, can I ask you, because I mean, I've been working on the assumption that in the room we have video game developers that are working with AI or AI developer. Is that correct? I don't want to say that some of you look like a lawyer. I mean, I don't want to make it so personal, but it would be nice to know so we can pitch it differently. Is my assumption correct? Generally, yes. So in case, I'll try to read your faces in case something doesn't sound right, I'm gonna change the pitch. So I'm Gaetano Dimita. Thank you so much for giving my entire title and the university without breathing. That's very, very difficult. It's a long title and it's a long name of the university. And basically, my entire academic career has been entirely focused on video games. I'm one of the lucky ones. I teach interactive entertainment law. I do research in video games and new technologies. I come from IP. My love is IP, so thank you very much for inviting me to talk about artificial intelligence and video games. And it is fascinating. I mean, it's really fascinating for me as an academic because, of course, we sit in the back, we try to create as many problems as possible so we can conduct our research. And of course, I don't have to deal with it in practice. So I'm much more lucky than Nicole and Andrea because I can think about it and work on the different alternatives. And it's exciting for me. But of course, if you're working in the field and you have to take a decision in 5 minutes on whether or not to use something, might be a totally different, emotion that kicks into places when dealing with artificial intelligence. Because first of all, we have to remember one thing. I mean, video games, they tend to do first everything. I mean, everything we experience in lives technically starts with a video game. I mean, most of the new technologies, probably the most expensive piece of equipment you have at home is what you play video games on. So this is how we embrace sometimes and understand technology through a video game. The success of the metaverse is entirely based on the success of multiplayer online games. I mean, no one wants to play on, I shouldn't say that while being recorded, but I mean, let's say the metaverse doesn't look so exciting to be in. There are other games that might be much more engaging and exciting to be. So this is my point of view, and video games are complex on a number of different levels. They are complex IP product, they are entangled in a complex contractual matrix, and then they're distributed globally, so they have to deal with regulation. Technically, everywhere on the planet, of course, we make a selection. We only deal with the regulation of the countries we care about. So if you don't have any assets in country X and you don't plan to go on holiday there, you can avoid dealing with the regulation of that country, but that's a business decision. Because if you distribute globally, then everything is applicable. And they're not just video games, because depending who I talk to, because I mean, in the peculiarity of my jobs, most of the people I meet, they feel like they have to tell me if they play or not video games. So most of my conversation with sometimes politicians or regulators start with, I don't play video games. That's the first thing that they want to tell me. But they're not just Super Mario or the video games from the arcade. Now, video games and the video games environment are evolving so much that social medias are video games. Twitter, okay, sorry, now rebranded X. Technically, that's also a game. And they are becoming permanent in a lot of different aspects of our life. When it comes to AI, with these premises, AI has been used in video games for a long time, even before we were calling it AI, and before we had this focus on generative AI on an IP perspective. Even if it was more archaic, everything was built in trees and libraries, we had a tendency of use this technology in games for decades. And when it comes to days of the use of AI in video games, generally facilitating and enhancing creativity, making creation of content faster, speedier, and more accurate to some extent, enhancing experience. A lot of governance within video games. I mean, setting up, players for online matches is not done by a person that chooses the character and determine who you're going to play against. It's done by AI, including content moderation. Most of the time, within video games, but now also on social media, but also are the first kind of pure content on which there's been a more complete experimentation of using the machine to create independently. I don't know, have you ever played any AI games? I mean, I don't know if I can do promotion, but I mean, a nice one to play is Dungeon AI. If you play Dungeons and Dragons, it's the kind of, you type something, the machine replies, you build a story together with the machine. Sometimes it's a good story, sometimes it's a really bad one, because it depends on the prompt and depends how the machine has been trained. But there also been, at the moment, academic experiment of having algorithm actually creating games and playing games by themselves. They don't tend to be the best game at the moment, but at least it's something that can be done and has been done. But looking at IP, and I don't remember which arrow is the right one, this is what I meant with when I say video game is a complex IP product or service. Every form of IP can technically protect different aspects of a video game. And video games are complex, are complicated. We have in the Court of Justice that looking at a video game said, okay, it's a complex subject matter. I cannot phrase it in a different ways. And of course, the determination of whether something is protected or not, it doesn't follow my list. It follows on whether or not all the criteria for that particular IP protection are actually applicable, on whether or not, for instance, copyright, the work is original. In some jurisdiction, whether or not it's fixed, if it's belong to the category. In the UK, same with patents, same with trademarks, same with design right. Trade secret, I'll keep it away. You anticipate we're going to talk about it later. I really hope not, but I'm happy to talk about trade secret too. So video games are generally already complex to look at from an IP point of view. And this is, for instance, one of the slides, because of course, I mean, talking with developers and trying to explain the importance of IP, not only, you know, the risk of infringing and getting entangled in a lawsuit or getting your video game taken down by the online platform. There is also the proactive activities you have to do in order to maximize the IP protection of what you create, on what you invent, on what you're making. And normally, when we're talking about risk assessment, I always put AI and open source, you know, over there. It's not highlighted, and it's always in the middle. It's always a potential risk. It's something that has to be addressed at this point on a case-to-case basis, because we are still in an early stage, and most of the time the answer is not straightforward. And even if it's straightforward, there's always going to be that jurisdiction in which it might be different. And looking at the global environment, especially if you are putting substantial investment in that particular assets, it's better to have your idea clear. But first of all, and I think Andrea already mentioned it, before using any tool online, do what no one does. Read the terms of services. Because in a period in which there is uncertainties, contracts are stronger than ever. And also contract, even when some clauses are technically not enforceable, they still create the trend. They create this understanding or misunderstanding that what you're agreeing is enforceable, and is actually enforceable. So look at the term of service, look at the IP clauses, look at what they tell you you have. Because for instance, I think Andrea this actually saying worse. Most of the time they give you ownership of your copyright. But do you have ownership of, is there copyright in the first place anyway? And what will happen is someone using the same system creates a very similar image. Can you actually sue them when they're using the same software to actually create that image? These are all questions that at the moment they cannot be spelled out in the term of services, because they don't know, we don't know, and it's really difficult to anticipate how the courts are going to approach this specific question. But it's important to check for system, and honestly, both Stability AI and Midjourney, they spend some time trying to create a more business-friendly environment, because, you know, in business, sometimes it's most important to have a kind of clear opinion that is probably yes, instead of ever certainties, instead of just having, you know, I don't know. So let's see how it goes. It's never the best approach looking at the future. And I would like to separate my 20 minutes in two parts, one on the outputs and one on the input. On the practical aspect, Andrea and Nicola did an amazing job. I have nothing to add. So I'm just going to make it a little bit more complicated and look a little bit more on whether or not this is a new thing. Because if it's a new thing, I don't know whether or not we're going to fix it or not. While if it's an old problem that we always add or it keeps recurring, there are more chances we can predict how the evolution of the system is going to look like in the following years. And when it comes to the output, at the end of the day, the only important questions to answer is whether or not you can identify a human author and whether or not the work is original. In copyright, these are the only two questions we have to ask. For trademarks, we can actually jump the discussion. I mean, you have this image, you try to register for as a trademark, it's capable of acquiring distinctiveness, and there is a connection with the provider, no question asked. There might be a problem with a potential opposition if someone can show that they have a pre-existing right of that particular logo. But that's not a problem. Patents, we know, just don't mention AI as an author, as an inventor. I mean, basically, that's the end. Pharmas, they're already abusing AI in their patent, even if it's up to 95% created by an algorithm. The important thing is that the inventive step is still something that is human. When it comes to copyright, however, it's fascinating because I've been working on this aspect of copyright pre-generative AI because I got fascinated by a number of cases in the history of copyright in which people were claiming that the work was dictated by God, by a ghost, or by some ancestor. And there is case law. I mean, you know, the advantage of being academics, you can waste time reading stuff that no one else cares about. But this has been quite common in copyright. People sometimes claiming that, you know, this book is amazing because a medium dictated that to me, and it was Julius Caesar telling me what to write. In that case, court, both in the UK and in the US and in continental Europe, were always being very clear. I'm really sorry, but copyright, even if it's not written in the law, is something human. If you're not human, you cannot be entitled to copyright protection. So a ghost or a god cannot be an author of a work. Could be a practicalities or could be something that creativity is fundamentally human. I mean, this is part of the justification of copyright. I mean, we can see it in all the justification and origin standard around the world. It is the human that create. But it was until recently that became a major academic question. And it wasn't for artificial intelligence. The major discussion, it was for Naruto. That monkey that you see is not a monkey. I'm sorry, I shouldn't say, I don't remember what it is exactly, but it's not a monkey, but she took a selfie. And that's created case law worldwide and a lot of discussion between IP experts on whether or not she was the photographer, because technically she clicked the button. And case law in the US, the photographer changing their version of the story a few times in order to prove a point, and PETA, the Association for Human Rights, for Animal Rights, getting involved, because of course, I mean, Naruto, the monkey, sorry if I call it the monkey selfie, if the monkey is the author, the monkey owns copyright, but of course the monkey cannot exercise copyright, so PETA should take advantage of the economic benefit of these photographs. But this wasn't the first time. This wasn't the first time that the originality, because of a technical interaction, became fundamental. In that particular case, for instance, for this photograph, because of the originality standard of photography in the US and in the UK, actually the photographer was the creator, was the person that put everything in place for a photo to be taken, so pressing the red button on the camera is not what makes you the photographer, is arranging all the creative choices. Remember that at the center of the slide there is degree of creativity and control that I guess is going to be the bottom line of my analysis on outputs. But in copyright, we always had this problem whenever there was a new technology. This very famous picture of Oscar Wilde, huge discussion on whether or not that was going to be protected, that ended up with a constitutional claim at the Supreme Court in the US. on whether or not there is originality in a photograph. And this is where copyright can get a little bit tricky, because originality, we all define it in different ways, in different jurisdictions. But we also look at originality differently depending on the work. I'll give you an example. We have a photographer running around taking pictures. Those pictures are original in copyright sense, because it's choosing the angle, it's choosing what to take the picture for, the lighting, and so forth. There are a lot of creative choice, and there is a lot of control. He decides when to take the pictures. At the same time, we're being video recorded. That in copyright is a film. That film is technically original because I cannot think of any non-original films when it's argued in court, because they are creative decision. Even though no one has been touching that camera since this morning, and I'm not going to investigate if there were any discussion on angle, positioning, where to put the center, the timing, and so forward. That is automatically protected by copyright, is original. That means photographs and the video recording are protected for 70 years after the death of the author, and they have full copyright protection. But at the same time, someone else press the record button on an audio recorder, probably. In that case, the same pressing of the button is not protected by full copyright. It's not protected by author's right. In some countries, it's by neighboring right, and generally is protected for 50 years after the 31st of December of the year in which the recording has been taken place. So there are three situations in which someone just presses the button and he has different consequences in copyright. And if you think about it, we had this discussion for ages. I mean, for photographs to be fully protected, we still have discussion on photograph, on originality. For music, for sound recording to be protected properly, took, what, 100 years? Since the invention of the recording machine, and there's still profound discussion on protectability of new subject matter created by new technologies. So it is good, and we're going to have this discussion about artificial intelligence and generative AI protectability, output protectability, probably for a number of years. As it stands today, they're probably not protected. And when I say a work that is entirely protected by, entirely created by generative AI, just by the use of prompts. And in this case, I think there were about 200 prompts. This picture painting photograph, I don't even know how to call it, this digital image, that's definitely correct. This definitely won a number of prizes. And then later on, it was admitted it was entirely created by generative AI. They kept the prices, but a lot of digital artists started complaining, this is unfair. The prize is supposed to be given to a human. It is interesting. I mean, it's a very beautiful image. However, in order to determine whether or not it is protected, we have to determine whether or not it is original. So, for instance, in Europe, it should be the author's own intellectual creation. In the US, should be something with a modicum of creativity and created by humans. Now we will see the guidelines. In the UK, should be the result of labor skill and or judgment. In all the cases, there are on the originality standard some human aspect, because taking decision, it is a human. Taking creative decision, it is a human prerogative. The machine, sorry if I diminish it and call it the machine, didn't take any creative decision. It wasn't making a judgment on whether this color is better, this other color is better, where to put. That is what is copyright is there to protect. But since the explosion of this kind of images, especially in the US, the Copyright Office started issuing guidelines. And they point out that they're not going to register works created by artificial intelligence, animals, and superior beings. Getting back to the cases, God told me about these stories, and I'm writing it down. But this doesn't solve the problem, because depending on the different originality standard, and notice I'm spending a lot of more time on originality standard than authorship, because authorship as it is, we can simplify it in one sentence. In civil law countries, where the justification of copyright is based on a creative human effort, it's really difficult to imagine a non-human authorship. While in common law countries, they're already present, and being more a property right is quite linear to envisage to some extent the possibility of having non-human authorship. We give ownership to legal persona. There are provision on computer-generated works that have been mentioned already. They're probably not applicable because they are reconnected to originality, but there's things that have been already there before generative AI. So in common law countries, US, UK, it's much more easier to imagine a quick switch because of the protection of the investment. In civil law countries, we are much more romantic in the way we view, we see creativity, and so there might be an obstacle. But this doesn't solve the problem because, of course, now there is a war going on. Someone wants a work generated by AI registered by the Copyright Office in the US because that would prove that the AI can be creators and they can reach the originality standard. And Castanova has been at the forefront of this attempt, having a couple of registrations already denied. At the moment, she's seeking registration for this work. And this example is really relevant because this is what happened in practice. It's really rare if you're working on a video game project that you go on Midjourney and you say, okay, create me something like an orc in the desert. This is not the way it works. The way it works, you already have your sketches, you already have your ideas, and you might use AI to actually develop that ideas, and then you render it later. So we're not talking about works that are entirely created by generative AI, but generative AI is actually enhancing and simplifying, speeding up, reducing the cost of that particular creation. And this is an interesting question, because while the sketch on the left is protected without any question, it is original, human author, it is a sketch, so in every jurisdiction that will be protected by copyright. The enhanced version is an open question. Is the enhanced version protected because there still was a human author behind that had the degree of control? Plus, it's not random. There have been probably 500 attempts in order to make it until the author, the original author, the human author, actually decide which one to use. In that case, it's still borderline, but this could be a work that is fully protected by copyright, even though it's being created by generative AI. Why? Because there's still a human with a clear degree of control and showing the creative choices in the creation. So a human participation, AI, generative AI cannot replace human creativity, because even from an IP perspective, as it is today, in a second we will look at the future, there must be a human. The human is fundamental. And probably in the long run, if you're thinking of the economics, the human might be cheaper. The human might be very much cheaper, because then you will not have to defend it in court that you actually own the copyright of that particular creation. That might be more expensive than paying a designer. On the input, amazing job. Actually, I was impressed that you did it in only 20 minutes. There are a lot of questions that you cannot honestly answer with a yes or no for every single jurisdiction. I mean, the answer might change. For instance, a doubt that I have, but it's becoming an essential doubt, I started questioning whether or not there is a reproduction in the first place. We will leave it if we meet later on with one of the beers, because it might be an intense conversation. But it doesn't sound reproduction in pure copyright sense. Yes, it is a copy. It is a reproduction in English. But when you look at the definition of reproduction in specific jurisdiction, it might not qualify. But of course, I mean, this is never going to be discussed in court, so I'll stay with this doubt for forever. The second point is, in order to avoid for it to be an infringement, if there is a reproduction, you have to have limitation exception. But limitation exception are local. They are jurisdictional. In Europe, there is a certain degree of harmonization, but they did it in a very interesting way. I mean, in the US, there is fair use. But fair use, there are a lot of people that are a big fan of fair use, but fair use works only in the US and works only if you have a lot of money to spend on litigation. Because, of course, it is a defense, you have to go to court, and you have to spend the money. But in fair use, for instance, there is this massive argument of fair use, but if you look at the case law, and we're not going to do it together, just check Authors Guild, fair use was applicable to the input just because the output was not infringing. So it creates for a discussion of what you're creating. So you cannot just say, no, it is for use and no problem. If then the output is an infringing asset, fair use might not apply. At the moment, it's not a problem because we're not looking at a case-to-case basis, but there's been a precedent. I mean, Google a few years ago photocopied the entire planet and got away with it because it was for use. But if you notice, you cannot access the entire books on the Google Book project. You can only access snippet. Otherwise, it wouldn't be fair use. But so they're different. They apply differently. And in the EU, what we did, unfortunately, we split the commercial and non-commercial text and data mining, creating two separate levels, and the commercial one gives the opportunity to opt out. So there are some complexity. The UK just says, I know we Brexit, we don't want to do it. On the final point that I wanted to make, because the rest has been discussed already, is that no one standing in might not be an infringement. And I don't want to make the praise of IP here. I mean, this is not my place. But the importance of getting licensed data is not, I don't think it's more important in order to guarantee data accuracy and to be certainty of where the data is coming from. Actually, that is more important than the infringement, in my opinion. I mean, I don't want to make it an economic analysis, because the thing is scrapping everything without checking and without checking the source is what is creating what I call, I mean, there is a different term, but when ChatGPT hallucinate and start making up, things that are not real, they are totally fake. This is probably because the data was not good data, and the data becomes the most important thing in the training. So having a system of licensed, authorized, vetted data, actually copyright could be something that beyond of the issue infringement could be something helpful in order to guarantee certainties, and also liability and responsibility, because the advantage of a copyright license is it goes over just authorizing access to the data. On top of that, and this is my last point before moving into quickly on policy, is that it is already here. So all the discussion we're having is on something that is growing. Artificial intelligence now has been totally integrated to some extent with open source, and the fact that you can actually run your code on this system in order to check or in order to make correction. And yes, there are massive IP implications, but also remember trade secrets and whether or not you sign an NDA. You are technically uploading your code to a platform, and then your code becomes part of the database. So there are all things that you have to take into consideration. So use at your own risk after reading what the term of service says. And on top of that, even a platform like Unity is already integrating AI. And the way they are doing it is with content and data that is not third-party owned, with entirely internal data, because they are already anticipating the potential risk who have corrupted data or bad data in their data set, not only for them as a company, but also for every single video game developer that is using that particular system in order to create content. So, layer and layer of complexity. I'll try to be short. Let's move into policy. Because at the moment, everything is fine. There are a little bit over 30 ongoing cases, but they're not in jurisdiction close by. There is a lot of wait-and-see approach, and generally, historically, in copyright and in IP, we dealt with new technologies and new problems always in the same three ways: reform, do nothing, or create an ad hoc system for that. And do nothing is more or less what we generally do for a long period, because copyright reform is messy. It's messy, and we just, for instance, in Europe, we just got away, we just finished the Digital Single Market Directive that was very stressful for a lot of people, and there is a lot of PTSD in the lobbying department. They don't want to have another directive. No one wants to have another directive. Maybe WIPO wants to have another treaty, but it's something that is very time-consuming, very risky, because of course, I mean, we all have different interests in artificial intelligence. So the moment you try to create a new piece of legislation, it's not given that the result is what you wanted. Publisher, artists, AI entrepreneurs, video game companies, users, we all want something different. So it takes a lot of time to do something. So copyright reforms is always probably the best way if it's done in a proper way, if it's done with the correct input and in a very balanced way, but it might take ages. Do nothing is probably the safer option at the moment, because we didn't even test it yet if the IP regime is fully capable. I mean, the IP regime is flexible by design. So until we don't know whether or not there is a failure in the system, probably touching something is not advisable. But remember, IP has been evolving for 300 years and is going to keep evolving. So reform is going to come. The last 30 seconds, because I'm not a big fan about sui generis right. And I mentioned the two precedents. Semiconductor topography, that I don't know if anyone ever heard of. That was a huge discussion on whether or not they need sui generis protection. They got sui generis protection. I'm pretty sure probably there is a piece of legislation in Serbia to protect semi. Who cares? No one cares. There have been 2 cases in the last 30 years. The companies are so big that it doesn't really matter. That was an insane discussion in my youth on semi-product. The second one is database right. That it was something we've been questioning for the last 15 years at European level. And the last time we asked member states, they told us, you know what, it's a terrible system, but let's keep it because it would be even worse to change it. So not a good idea in general. I mean, South Africa, they had sui generis protection for software. Not a single case since they introduced the new legislation. So it's really risky. And again, the threshold for protection is really low already, especially for copyright. Do we really want to protect everything? Because it's a double-edged sword. The more to protect, the more you protect, the more you risk to infringe on the other side. So the balance is always more advisable. And on that, I conclude. I think it was the last slide, because the rest is about WIPO promotion, but you will get it.
Thank you very much, Gaetano, for an interesting talk.